Start. Both the appellant and respondent number 1 had filed applications for being impleaded as parties in the said writ petition which were allowed, and both the appellant and the respondent number 1 had been impleaded in the said writ petition. The said writ petition was disposed of by this court by an order dated 3/2/2010 directing the DDA to dispose of the claims of all the three claimants, namely the appellant / plaintiff, respondent number 1 and respondent number 2 / defendant number 1 after hearing the said parties. The appellant filed a suit being CS number 1098/2008 inter alia seeking a decree of declaration that the plaintiff was the owner of the suit property. The plaintiff has further sought a decree of possession directing the DDA to hand over possession of the suit property. In addition, the plaintiff has also sought a decree of mandatory injunction directing the DDA to execute a perpetual lease in respect of the said property in favor of the plaintiff and defendant number 1. Respondent number 1 filed an application being IA number 15286/2008 under Order 1, Rule 10 (2) of the Code for being impleaded as a party in the said suit filed by the appellant / plaintiff. The said application was not opposed by the respondent number 2 and the DDA, defendants in the suit. However, the plaintiff opposed the said application, contending that respondent number 1 was neither necessary nor a proper party to the proceedings filed by the plaintiff. It was contended that respondent number 1 was claiming a title adverse to that of the vendor from whom the plaintiff had acquired the title of half share to the suit property, and this dispute could not be made the subject matter of the suit filed by the plaintiff. The appellant further resisted the application filed by the respondent number 1 on the ground that the appellant was dominus litis. The learned registrar accepted the contention of the appellant and rejected the application filed by the respondent number 1 by an order dated 14/12/2010. Aggrieved by the order dated 14/12/2010 passed by the learned registrar, respondent number 1 preferred an appeal under Rule 4 of Chapter 2 of the OS Rules, which was allowed by the impugned order. It is not necessary to examine the rival contentions on merits to consider the preliminary objection raised by respondent number 1 regarding maintainability of the present appeal. The only question that arises for our consideration at the present stage is whether the present appeal is barred by virtue of Section 100A of the Code. Thus, the expression appeal occurring in Rule 4 of Chapter 2 of the OS Rules cannot be considered to be an appeal in the true sense. The powers exercised by the learned single judge under the said Rule 4 are in essence powers of review. As such, any orders passed in respect of a challenge to any order passed by the registrar would be an order in exercise of the original civil jurisdiction and not appellate jurisdiction. Over.